Okay, so hello again, everybody. Thank you for joining another of our Around the World with TJ webinars. And as most of you will know, what we're attempting to do with this series is to really try to bring together colleagues from various geographical locations so that we can share research and share ideas. Today, we will hear from colleagues from the Netherlands, and I'm just going to introduce them really briefly. Professor Arno Akkermans is full-time professor of civil law at the VU University in Amsterdam. His research focus is on the impact of law and legal procedure on the well-being and health of individuals in the context of civil procedures in general and the settlement of personal injury claims in particular. Arno works with multidisciplinary research teams and cooperates with colleagues at the Faculty of Psychology and at the VU University Medical Center. And I have a feeling your tech person is coming in to help you. Is that correct? Okay, I'm going to continue. And if you need to do a switch over of your camera, that's just fine. Iris Bex is with us as well. Iris obtained her master's degree in victimology and criminal justice. She's currently finishing her PhD on victims of traffic accidents and the legal procedures they go through to claim compensation. And the main objective of her research projects is to study what insurance companies, lawyers, and judges can do to make personal injury procedures more restorative. I think that's super interesting. I love to hear both new thoughts on topics that we've discussed before and also kind of newer topics that we actually haven't heard a lot about. So really excited to welcome you both, and I cede the floor to you.
Well, thank you, Shelley, for your wonderful introduction. Yes, it's true, you know, we are living the modern life with all kinds of technical hiccups. So as we are talking, we are trying to use another screen with a better camera, etc. But we'll just continue. I will share our PowerPoint presentation with you. So our presentation today is a bit about concepts. So we have some thoughts on the concept of responsive law, which is in the Netherlands. We're giving this presentation from Amsterdam in the Netherlands, and here in the Netherlands, this label, I would almost say, label for all kind of innovative things that are going on in our legal system is becoming more and more in use. And we've discussed it, we gave it some thoughts, and we think it's not such a bad label at all in the end, as to present a more or less overarching conceptual framework for all these vectors of innovations within legal systems of the world. So that's what we're going to, I'm not sure we're suggesting to use it, but we would like to discuss with you to what extent that could be a useful overarching conceptual framework. That's been the main thrust of our presentation. And I will do the intro, and Iris will give will zoom in on certain details of all these, you know, schools of thoughts and attempts to generalize what's going on. I remember when I was attending a conference in Puerto Rico quite some time ago, David, that we were all also at that time struggling with things like, to what extent is TJ a theory, stuff like that. And at that time, I wasn't so much, well, wasn't interested. It wasn't main part of my intrinsic personal motivation. I just wanted to get a lot of things going. And TJ was, well, simply, I felt that I was in the right in the right company of the right kind of persons who really wanted to contribute to certain changes within their legal systems and that of other countries. But, you know, as years come, you start to think on the different levels too. So this is more or less of, maybe it's 10 years too late, but I think to some extent, we now have a beginning of an answer to what extent TJ is part of a theory. So for the most of you, it will be, you know, obvious that many jurisdictions in the world see innovative initiatives. They do take place in all kinds of areas of law and within various sectors of society, and they are provided with various names and labels. And most of these initiatives are bottom-up. Most of the time, they are taken by frontline legal professionals who are striving to make the work more effective and societally valuable. And these innovative developments have, of course, already long been the subject of scholarly attention, but the truly overarching scientific discourse, and with it a generally used overarching conceptual framework to describe and interpret these developments, seems to be lacking so far. So there are important schools of thought, for instance, like therapeutic jurisprudence, of course, and restorative justice. There have been some attempts at an overarching approach, like the non-adversarial justice conferences that took place in Australia twice, I think. And of course, Susan Dakov's beautiful work on comprehensive law, where she's also describing what she labeled vectors of innovation and how they would relate to each other. And in this presentation, we are going to use some examples from Dutch practice to illustrate how these schools of thoughts from which these innovative developments are approached and described, how they interweave with each other. And then we will come to the main point, discussing the potential of this concept of responsive law that was introduced by Nanette and Selznick as an overarching conceptual framework. So what kind of innovations are we talking about? I will come back to this table a bit later when I've given some illustrations. But if you try to describe them on a more abstract level, there is what they have in common, all these initiatives. You could, so that there are development from traditional to innovation. And on the left side in this table, there is in key words described what kind of traditional elements you will find. And on the right side in innovation, there are these keywords. So what happens in these innovative initiatives? So from procedure-oriented to solution-oriented is, of course, a central one. And that we're trying to get away from adversarial procedures to more consensual procedures, where parties contribute to the solution instead of battling in the legal arena. It's also an obvious one. When it comes to the activities of the courts, it's more than legal decision-making and addressing the legal dimension, but a more comprehensive approach of problem solving. That's, of course, a very powerful label, problem-solving courts. Addressing underlying interest, problems and causes, and addressing them by trying to be part of the solution. More in the background, you see that the traditional legal discipline has a rather limited perception of the needs and interests of party. They mainly focus on pecuniary needs and interests. And these innovative initiatives have generally a more broader conception of needs and interests of party, including emotions, non-pecuniary needs and interests, and of course, therapeutic interests. The classical paradigm of the judge is a decision taken by the third party. And what we see is that things are getting blurred. You have osmosis of these traditional decision taking by third parties with more consensual elements. So the solution awfully is at least partly reached by parties themselves. We have the traditional paradigm of the procedurally passive judge on one hand, and in all kinds of innovation, you see that the decision taker, whether it's a judge or someone else, is procedurally much more active. You have really very far-going initiatives, for instance, in what would be labeled family courts. Not really family courts in our case, it's just the district court, but there's the family chamber. And there you see that they even call it the judge as a controller. The judge is very much in control. But we have that on all kinds of other parts of substantive law, where you see this really departure of this passive judge who's just listening to what the parties bring before her. And then also more psychological level for the lawyers involved, they traditionally have this system perspective, which is very dominant. And now the user perspective is prioritized. I think that's something very simple to say, but it really has a great magnitude, this shift of perspective, how you look at law and the legal system in general. And one of the things that you get then is that you often have several formally different procedures with different access points and counters. And what you see in all kinds of initiatives, you see back that what they're trying to do is create central access points, one counter, and then sort of triage happens this citizen comes with a certain problem, and not he or she, but the professionals that are behind that counter take their problem, their case into the right procedural avenue. So this is a beautiful Dutch text. I try to translate it at least a little bit. It's about experiments in the courts. I will zoom in on what the courts are doing, because I think there's lots of stuff going on outside court and in alternative dispute resolution and all kinds of things that could be labeled mediation in cases. But I think the courts are, it's most interesting, I think, for people from other jurisdictions. So what we see in the Dutch, within the Dutch courts, is that there is, on the one hand, there are an incredible amount of experiments. And on the other hand, there is a gradual, slow, but continuous shift in what is going on in mainstream legal procedure, in both in civil law, administrative law, and criminal law. So these are the experiments. It's labeled in Dutch, maatschappelijk effectieve rechtspraak. I couldn't resist teasing you a little bit with Dutch language. Now, this is a more or less a PR, a PR thing from the courts themselves. If I would translate this, it would be societally effective judging. I don't think that you would ever say that in a native English native speaking country, but that's literally the translation. So it explains what does this mean. So it shows that these experiments take place in all kinds of different fields of law. What they list here are debts. There's a problem of people who simply have debts and that are at risk of going bankrupt. Neighbor disputes and divorce, of course. And then they say court seeks solution for all parties involved. Well, that's interesting. And it's fast, simple, cheap, and for everyone. I do not think that this is really a very good label, really addresses really what is really the content of the alternatives. But, and I tried to list them, there's simply too many of them. There are really dozens of different experiments going on, which is a lot if you think that the Netherlands is a rather small country with only 80 million inhabitants. And at the same time, there are gradual changes in mainstream civil court procedure. From one hand, it was traditionally an almost entirely written procedure, and now there's a very prominent role for oral hearings. And this allows all kinds of different ideas about what is really the role of a judge. There is a prioritizing of consensual contributions to conflict resolution over non-consensual ones, even within mainstream court procedure. And there's not only court-annexed mediation, of course, and training of judges in referral to court-annexed mediation, but there's also active distinguishing by the judge between issues on which the parties can reach agreement themselves and issues aided by their counsels, mediators, or comments of the judge, and issues for which they need an opinion of the judge. And this has even led to something that you could label a facilitating judge. And the idea is here that you have procedures, and we actually have legislation that has enabled this. Procedures are essentially consensual, so the parties have to try to reach a decision, to try to come to a solution on a consensual basis. It's not always called mediation, but I think that's the paradigm of mediation. The parties are assisted by some professional who is helping them to solve the issues. And then there's a whole list of issues and things that has to be addressed, and they can't solve all. So only for those that they are not able to reach consensus on. Then there's a judge, and that is quick, cheap, and for all parties it's quick. And this judge will, have a discussion. The issues will be discussed and addressed. And on those issues where they can't reach agreement, the judge will take a decision for them. And then there's not a verdict or something, then it simply goes back, the whole conflict or problem goes back to the negotiation table. And often the parties facilitated by the court will be able to reach a comprehensive solution. And that is a way of looking at for what courts are on earth, which is quite revolutionary from the traditional point of view. So it is really the courts facilitating out-of-court settlement, one could say, if you want to put it in different words. Also in criminal court procedure, there are gradual changes. Mainly where you see there's a growing of the number and growing of the emphasis on victim rights, but also a lot of victim offender mediation. It is often offered as an option in the prosecution phase, but it's also offered as a service independently of legal procedures, such as prosecution and trial. So it's simply parallel to what's going on in official procedure. And it's really very much about, here you, of course, you have very readily available the label of restorative justice. The restorative justice inspired innovations. That label is not always used, but it's the on an abstract level, the same kind of inspiration. So also here, in a way, and that's the parallel with the civil cases, you see that one is looking for a different division of responsibilities, a different role of the judge in relation to the parties. But of course, as criminal procedure is, it's much more. It's in an environment where you really have fundamental rights and a due procedure. The margins for it are a bit, different, probably also a bit smaller than in civil cases. But the tendency, the way, the direction that these changes are going, and also the inspiration that is the driver behind these innovations, is really very much the same as in civil cases. And the same goes for administrative court procedure. There you really have, because we had some incidents I think you could call scandals. I will not go into them, but it's already a thing with a lot of certain stories with a lot of media attention, and also an official apology by the central administrative court that they've been too formal and too strict and too legalistic, and that they've been listening too much to strict interpretation. There's really a rethinking of the role of administrative courts. And what they're trying to do there is to function less from the point of view of the criteria of the system. So what is, for instance, is something lawful, but more from the point of view of a useful and fair solution for the citizen. So with a bigger focus on justice. And here we see that the conceptualization that is generally used here is that of responsive law. So you see that the lawyer of the future is a responsive lawyer, and we need the responsive state. and responsive civil servant, and the responsive court, of course, and there should be responsive judging. And it's if you try to describe what is meant with this label responsive, that is really very much this shift in perspective behind it. In terms of Nonet and Selznick, and Iris will explain a bit more later, we come from a period in which law was very much an autonomous system, and I was educated as a lawyer 40 years ago, very much within that system. It is the system that directs your thoughts and that directs your initial responses to any given problem that is put in front of you. And this is gradually being replaced by that you look at it all from the perspective of the citizen, of the user, so to say. And then you see something different. You see that it should not only, solutions that you're working towards should not only be in accordance with the system, but they should simply be a response to the needs of that system. So the responsive element, an acceptable response, citizens want justice. They have no, it's not very important for them whether their problem is a civil case or an administrative case or a criminal case. They just want to have an acceptable and a just solution to their problems. So that is, I think, quite a major thing. And it's there, and it's very recognizable there if you take a look, whether or not it's labeled as responsive law. So that's what's going on. And now I show this table again. So this is, of course, it's just a preliminary effort into finding in catchwords to describe in a more abstract way what's going on. And I will be happy to put a wonderful Bob Dylan quote in that table, Michael Perlin.
Michael is thinking hard, Arno. I've got a couple of possibilities for you, actually. Most of these are words that Bob never used in lyrics, but I'll wait until question and answer time comes and I'll make a couple.
Well, so
I'm working. I'm not just sitting
there. Well, this table is obviously work in progress, and it's not intended to be the empathy of anything else. So, and then, of course, what does that mean for us? Because we, as a TJ group, are part of all this. And Iris is going to continue our presentation.
Yes, thank you. Yeah, as Arno has explained, we have seen new initiatives in Dutch society and how we are redefining legal procedures and how we are redefining new perspectives on the law. And in my presentation, or my part of the presentation, I would like to zoom into theory and how we can make sense of these new initiatives and developments from a more theoretical perspective. And I will try to use theory from different perspectives or levels, but I will come back to that throughout my presentation so you know what I mean. And I mentioned redefining legal procedures, and one of the main elements in redefining those procedures is how the law can be more useful and fair to citizens or the users of law. And this is where therapeutic jurisprudence comes into play naturally, which is the first theoretical base that I will touch upon. And by the way, seeing the audience that is present now in the Zoom, it feels quite redundant that I am explaining these to you, but let's go ahead anyway. So first, therapeutic jurisprudence. This is the interdisciplinary study of the law that includes the notion that it can have an enormous impact on people. And now I've italicized, or how do you say this, the law, because the law should be understood as rules and regulations, legal procedures, court procedures, and the rules of judges, lawyers, and other legal professionals. So all of these together are included in the law. So it's a very pluralistic notion. And I've written it can have an enormous impact on people, and that impact can both be negative. So people can find interaction with the law as very burdensome, but they can also find it positive. The impact can be positive. Therapeutic jurisprudence borrows from psychology, psychiatry, and criminology. So it studies what the impact is on people, on, for example, well-being. But looking from criminology, you can also look at effects on, for example, recidivism and desistance, so stopping crime. The notion of therapeutic jurisprudence is coined or founded by David Wexler and Bruce Winnick. And in one of the earlier works, they describe it as mental health law would better serve society if major efforts were undertaken to study and improve the role of the law as a therapeutic agent. And it was founded when Wexler and Winnick were working within mental health law in academia and practice. And issues such as the civil or forced admission of patients with mental illnesses prompted them to reflect about the effect of forced admissions on the patient. And the question arose whether the law improved the situations for these people or actually made it worse. So in other words, does interaction with the law make these people better, or do they make them more ill? And from this question, therapeutic jurisprudence arose. And whereas in the early years, therapeutic jurisprudence was seen mainly as a new perspective on the law, it gradually became associated with practice-oriented changes as well. Therapeutic jurisprudence advocates argue, for example, that a judge should not be a neutral judge, but rather should assume a coaching role. And that is also illustrated by the quote that I put on this slide. The essential task of therapeutic jurisprudence is to sensitize judges to the fact that they are therapeutic agents in the way they play their judicial roles. So we really should see legal professionals as agents that could have a positive effect on the people that are getting into legal procedures. In the same line, I would like to move on to restorative justice, and where therapeutic jurisprudence was born within the area of mental health law. Restorative justice was born within the context of criminal law, and it is typically seen as an alternative to criminal law. So, for example, where criminal justice sees crime and wrongdoing as something against the state, as a violation of the state and a violation of the law, restorative justice sees crime and wrongdoing as harm to individuals and as to their interrelational ties, and as harm to communities. Where criminal justice seeks to determine guilt and impose punishment, restorative justice is concerned with repairing the harm caused by crime and wrongdoing. And where criminal justice excludes the people impacted from the justice outcome, it excludes victims. Restorative justice includes the people most affected by crime, and they really should be included because they are key to the resolution of the harm caused. So this is quite a radical, different approach to our traditional system of criminal justice. Within restorative justice, the focus is on restoring and recovering, on a relational, emotional, and moral level. Relational is not applicable in all situations, but it can, for example, be in situations of violence between people that know each other. Emotional, because criminal acts can have a very deep emotional effect on people, and on a moral level, because being victimized creates this moral disbalance between the person who has harmed the other person this creates a difficult power balance, actually. Within restorative justice, there are certain forms of practice established, and these include victim offender mediation, circles, and conferencing. And one of the most well-known definitions of restorative justice is restorative justice is a process whereby all the parties with a stake in a particular offense come together to resolve collectively how to deal with the aftermath of the offense and its implications for the future. So now I've very quickly tapped into restorative justice and therapeutic jurisprudence, but how do they overlap? Do they overlap overall, but also how do they overlap? First, I've seen that in practice and academia, restorative justice and therapeutic jurisprudence do not really seem to mix. For example, if you go to an international conference that is mainly geared towards restorative justice, the term therapeutic jurisprudence is most likely not mentioned, and vice versa. And I think that's quite peculiar because I see quite an overlap in these schools of thoughts. Because how I see it, restorative justice and therapeutic jurisprudence have in common a recognition of the importance of factors such as trust, procedural fairness, emotional intelligence, and relational interactors. And as I said, both are quite similar, but they started in different contexts. And they both also have the starting point of we as human beings interact with the law, and we as human beings should be able to profit from the law as well. But at least the law should not harm us any further. Therapeutic jurisprudence and restorative justice emerged as a result of the endemic failures of criminal justice systems in responding to, for example, drug and alcohol-related crime, mentally disordered and intellectually disabled offenders, high rates of indigenous overrepresentation in the courts and prisons, repeat family violence offenders, etc. So what we see is that therapeutic jurisprudence and restorative justice are new approaches to more traditional ways of dealing with harms and wrongdoings. And as Arno has already mentioned, one new way of bundling these approaches together, that way of bundling is done by Susan Dakoff in 2011, and she has presented comprehensive law as a way to bundle, for example, therapeutic jurisprudence and restorative justice. And I've visualized it here as a pyramid, but I just would like to visualize it as a way of an overarching view that includes these notions. It's an attempt to bundle. As she has coined it, this comprehensive law movement explicitly seeks to resolve legal matters in ways that are optimal for the individuals and entities involved in the matter, in terms of personal functioning, interpersonal relationships, well-being, and morale. To do so, it values concerns beyond simply the legal rights and obligations of the parties. This is a rights plus approach. And she includes 9 vectors, as she called it. And what you can clearly see is that all these approaches to harms all stem from different backgrounds. The purpose of all these different vectors is that they actually want to help people that come into contact with the law, although they stem from different areas. A similar approach is the non-adversarial justice movement by King, Freiberg, Hyams, and Batagol. I won't go into this any further, but I just wanted to mention it. But these authors have signaled a similar tendency of looking at the law and these different initiatives. They have bundled them in a very similar way, actually. Now, coming back to this pyramid, we see all these different approaches, but how can we understand those changes in a more social scientific context? And we've used the notion of responsive law for that. Responsive law comes from the work of Nonat and Selznick. I've included one of the more recent editions of their book from 2017, but they actually wrote the book, I think, in the 70s. And the book is a social sciences reflection on the position of law in society. So their work is an exploration of the purposes that laws serve in society. And they differentiate three different historical stages: repressive law, autonomous law, and responsive law. And I'll quickly run over them. So the first stage is repressive law, where law is used as a tool by the political elites. The law is subordinate to the political system and is used mainly for maintaining order. The law is a means to enforce obedience and to confirm the authority of those in power. So this use of law is quite pre-modern, and it is basically used to keep the elite in the saddle. And the downside of that is that although it is called law, it is not really just for most of the people. It is only just for the elite. And that is the first stage. And the second one that tries to overthrow that huge downside to actually not being just is the second phase, where the law is playing an autonomous role or part. In the phase of the autonomous law, the law can also function as a full-fledged counterpart to politics, whereby countering the abuse of power and oppression by the political elite is an important function of the law. Laws, rules, and procedures occupy a central position to this legal framework, and the principle of the rule of law applies. So what you see here is that within this phase or within this stage, the law has become a very stable element of a democratic society, and people can really count on the law. And the law is predictable, because if you get into, for example, a court procedure with a similar case, you will get a similar outcome. However, as administrative organizations become more and more institutionalized and the complexity of regulation increases, the more the interpretation of the law becomes a matter of experts. So the downfall or the pitfall of autonomous law is that it becomes too difficult and too complex for regular people in society to understand it. So where it was actually found to be more to serve as a means for the people, it has become so complex that in its own transition, it has become too complex for people to deal with. In a reaction to that, responsive law is the third stage. And in this last stage of evolution, and implies that not procedures but principles take precedence. The law and legal institutions meet social needs, and the solutions are sought that can be characterized as just from a social perspective. Experienced justice is thus a more important criterion than the precise observance of legal rules. Those rules are means to an end. The end is justice, both material and experience. So what's unique about how we define law or justice within this phase or stage of responsive law is that we try to look at the situations that people are in and help them as unique beings and unique situations. I have visualized it here as a sequence with a beginning and an end, but actually Nonat and Selznick have said that it is some sort of continuous cycle, because the downside to responsive law is that you or that you may not always count on that predictability that is such an important factor within autonomous law. But what we are seeing now is that the initiatives that we talked about really seem like they can fall very well into this phase of responsive law, or at least in a sort of hybrid situation of autonomous law and responsive law. Responsive law does have a few very good qualities, but it is not perfect, and Nonek and Selznick say that it might very well be that we go back, or that we go back to, for example, repressive law eventually. We have now put the initiatives and the development into the context of these different levels of theories. It is, of course, not the only way of looking at them, but to us it helps to put all these developments into some sort of context to understand them in a more societal way. And I would like to end there. Thank you very much.
Thank you very much, Iris and Arno. I am going to appoint myself as the keeper of the list for anybody who has questions or comments. So, Kim.
So I have such mixed feelings about your presentation, because there is so much overlap in the work that I've been doing in the integrative law movement. And I'm really excited that you've come with a different lens from a different place and found so many of the same things. And at the same time, I feel like a complete failure for not having found you sooner. That's my job. So I have probably, I don't know, at least a half a dozen, maybe a dozen people in the Netherlands who are doing things that you're going to want to know about. And I'm not sure how, you know, and then also there's a book in Flemish that you might be interested in. And so I'm gonna just create a message in the chat and do that. But one of the things that integrative law has been looking at is like the in that user oriented space is things like legal design and contracts, the transactional world. We're looking at multidisciplinary models and collaboration and things like that, but we have not seen personal injury show up. So there, so I think I just want to say that we have a lot of things that we can talk about, and maybe we need to have that. But I want to show you one thing. Can I share my screen? Yeah. This is our what we're currently doing with explaining integrative law, is that the values have changed in society, and we've created a new DNA that this sense of our interconnectedness that comes on the end of like the internet and you know, the pandemic and all of that kind of interconnectedness, as well as some people have this spiritual sense of interconnectedness, and that from that has grown a beautiful garden of different options that started with the ADR movement. And so my books are Lawyers as Peacemakers, Lawyers as Changemakers, and Trauma-Informed Law, all published by the ABA. And Susan Dykhoff apprenticed with me to, or studied with me earlier last semester in my integrative law class at Quinnipiac University School of Law. And so so I am teaching, I'm writing, I've got a couple of articles that I can send to you, law review articles, as well as the 3 books. So I just, I'm really excited to compare our notes at some point when there's more time.
Wonderful image, Kim. Beautiful.
One of my students created it. And one of the things, by bringing in that design element into the law school, we've had the most amazing creations. Students who've not previously been artists have accessed that creativity, and it's actually changed the path of their career. And so we're really excited about that. And then also I'll mention, because David was one of our guests, we have a podcast, the Integrative Lawyers of the World. And each series represents 6 continents and 6 integrative lawyers who are doing different things around the world. And so David represented North America in our last series, but we have also some Dutch women who have been working with the design school in the Netherlands and Amsterdam to create a compassionate court, and they actually are building the court that the design school and the law school work together to design it. So that's just a little tip of the iceberg of some of the things that I think you'll be really interested in. That I'll be a little off camera while I'm putting together a message for you.
And
Thank you.
that's great. And that's one of the great things about these webinars, right? Where we get to connect people and share ideas about others who are doing similar work. So that's fantastic. I see David Wexler, and then I know that Michael also has a question or a comment. So David, do you want to start? And then Michael will.
Yeah, I do. And I think what Kim has just said is right on point, that really what she has done is taken all of these different vectors and accepted them and put them into use and has drawn on people to give their talks. And I thought it was a great experience to participate in that. And I certainly think it's, you know, as we get into all of these things, that her work and the integrative law movement is important to look at. There's an amazing overlap and things that add to it. I'd like to mention a few other things. So restorative justice used to really be something that I think disliked the law. They wanted no part of the law, and that was one of the problems. One of the problems that TJ had in trying to use anything like that. That has started to change in a lot of ways. And just as TJ started to go from problem-solving courts into mainstream stuff, so too restorative justice has tried to do that. And they are now closer together, I think, than they've ever been. And there have been situations. I worked with Stella Maris, who was at our meeting from Argentina, our meeting at the TJ meeting, and is still here enjoying Puerto Rico, by the way. But she and I did something that was inspired by Tali Gal from Israel, who's a real expert in restorative justice, but also is a real expert in therapeutic jurisprudence. And she's the one who tried to kind of talk about how we had a myopia of each other, and we needed to learn more about each other. And she had some suggestions. And after that, I noticed that Stella Maris, who was really an RJ person, and I, who was more of a TJ person, came together to realize something came out from the restorative justice journal, talking about, you know, in restorative justice, we have a little bit of coercion. We don't like to call it coercion, but we have to think a way of being honest about it and what we're doing and all that stuff. And I realized that, you know what, we had that issue in TJ, and Bruce Winnick had kind of resolved that issue, to my satisfaction anyway, 20 years ago. And if we knew something more about each other, we'd be able to do it. And we ended up publishing a piece on that. I can go into it in more detail if you want, but it was really Winnick who said, you know, if we add drug court as a possibility to your other, to you who are under arrest because there's probable cause to believe you violated the law and all that, that is something we're adding on. You don't have to accept it, you know, and therefore in that sense, it's not really coercive. And I think really it answers not only the issue for TJ, but I think it seems to me, answer it for the RJ stuff. So I do think they're coming together. And as they're trying to mainstream, now the restorative justice people are less us objecting about RJ having some place in the legal system itself. And so there's lots on that, but I just want to mention that it seems to be coming together in a very appropriate way. One other thing I wanted to mention was something that Michael Jones, who's passed away now some years ago, was a wonderful person in TJ, and was a lawyer, and was a judge, and was just an amazing person, and he was doing some kind of criminal settlement conferences, and he got involved in that from a TJ point of view. And it was very, very interesting what he did and how he met with families and encouraged them to speak and all of that. Very, very interesting thing. He also came up with something that I thought was fascinating, and unfortunately, he passed away before it really could be implemented. But he had come up with when people were trying to resolve, say a criminal case, he wanted them to talk to each other and to suggest things and see if they could come to some agreement, and all of that was fine. But he drew on something else, and we wrote something together, and it actually came out of arbitration, but it's called the last best offer rule. And the purpose of that is to really say, what he would say to this is, look, I'm going to work with you folks to see if we can resolve your question, your issue in a criminal settlement conference. And if we do, great. But if we don't, I'd like to try something else. I would like you all at the end to submit what you call as your last best offer. And what I'm going to do, with your permission, is if we do this, if you don't come up with a resolution, I'm going to come up with my own that I'm going to present. And if the defendant agrees to this, then the case will be over. And the key here, he says, though, is that I will tell you what, you will all talk about this, and then I will ask you to provide your last best offer. The key is I will not compromise between those extremes. I will choose one of them as my decision. And then if the defendant agrees with it, the case is over. If it doesn't, it goes back to court for resolution. And he said what this does, and was really, really interesting, is it makes each person in the involved think about this, not only in their thing, but geez, if I push for this and the judge thinks I'm pushing too hard, then I may lose, and they may go to my opponent's suggestion. And so I better think about, maybe I lower my expectations, and so does the other person. And then they start thinking, and maybe they can come together right at that point. But if they don't, this last best offer is the brilliance in it, I think, is that I will not compromise. It's not like I'm going to just split the difference and give you that, which is what very often happens. And that procedure seemed to really have people think about their own situation as well as their opponent's situation, what they were asking for, what their opponent was asking for, and see if they can come closer and closer together. And if they do, they may say, time out, and they go to the other party and try and resolve it right there. If they don't, then they take their chances. Anyway, I thought it was a beautiful, beautiful piece, and he was about to really start doing it, and he passed away. So I don't know that it's ever actually been done, but I think it's a very, very interesting addition to what we've all been talking about. So thank you. I apologize for my English. I can't keep it up to your standards, I'm afraid, but
Thank you, David. Great comments. Michael, did you want to jump in?
Yeah, a couple of things. Arno and Iris, I enjoyed this so much. I'm so happy that I was able to log in. Thank you very, very much. And I've got thoughts about 3 or 4, putting aside the Dylan quotes, which I'll do at the end, because I have a couple that may or may not work. I'm not sure. I have a few thoughts. Number one, on your first chart between regular law and what we're interested in, on the left side, about 4 or 5 down, you had by the judge, the decision taker is procedurally passive. And I disagree with that. I want to explain why I disagree.
Could you repeat that, Michael? What is it that you?
The decision maker, the judge, is procedurally passive. I spent 3 years as a criminal defense lawyer, 8 years representing psychiatric patients, both in individual cases and in class actions. And I ran a clinic in which I supervised students for 6 years, representing people in SSI and SSDI benefits cases. The judge was never procedurally passive. In the first 2 instances, the judge did everything he or she could to make sure my client lost. The judge's emotions were very clear. He wanted my client in jail. He wanted my client in the hospital. He would find anything possible to rule against me in any kind of a civil class action, civil rights, whatever. It was, kind of the game was fixed from the beginning. And I believe in many areas of the law, it is that way. We like to teach our students that the judge is neutral. I don't think that is so. And later on, when I did the cases in representing the SSDI cases, these were all people who had lost in federal administrative law judge cases, which were the same. But then we went to the federal trial bench, to the Eastern District of New York or the Southern District of New York. And that was the only time in my life I ever felt that globally the judges were passive and were willing to let the lawyers take their position and argue their cases. But I've been a lawyer for 13 years before that happened. So that's kind of one. Number 2, I saw, and we although it wasn't discussed much, it was at the beginning, or maybe it was in the initial mailing, about work with negligence cases and people who were injured in accidents, things of that sort. And I think it would be really fascinating to look at who goes into those lines of work. It's an area of law I've never practiced, and what their motivations are. I have a friend who used to work as representing defense counsel. She was a defense counsel in those cases. And she said, we had only had one thing: stall. Keep stalling as long as you can, because then we have the insurance money, we can invest it, we can make more money. Whatever there is, stall. File whatever motion you can file, no matter how harebrained it is. That was there. On the plaintiff side, a good friend of mine, someone very involved in TJ, used to work for a firm that did that, and she loathed it. And she was told, you can't ask these questions. You can't talk to him about this. You need to fill out these forms and find out this so we can go and ask for a settlement. We're not interested in any of this other BS. Now, I don't know how to, yesterday and a couple of days ago, driving on Route 95 to DC, I was looking at all the billboards for the negligence lawyers in Philadelphia, and there were people like with money bags in their hands. I mean, these were like the grossest billboards I have ever seen. And, you've got to wonder if folks like that are to any extent the majority of the lawyers who do this kind of work. How do we reach them? I have no idea at all. I'm not that smart, but it's just something, if this is your, let's say, target audience, this is one of your interests, your work is so good, everything you said is so inspiring. I don't have a clue kind of as to sort of how you can go about doing that. The makeup of those folks. Finally, before I get to Dylan, I've written a chapter in a book that is allegedly going to be published any month, who knows, and it's called I Hope the Final Judgment's Fair. That's a Dylan line. Alternative Jurisprudence's Legal Decision-Making in Justice. It is going to be in the Cambridge Handbook of the Psychology of Legal Decision-Making. And I do talk about TJ and RJ, how they're alike, how they're different. My early draft of that is on ssrn.com. Take a look at it. Maybe it might be of some interest. I don't know. Again, I loved it. The Dylan quote I like the most is the kingdom of experience, which comes from Gates of Eden, which is a terrific song. And I think that works. The only song I know that has the word negotiate in any sense in it is a line from the song Slow Train, which Dylan did during his Born Again period. And the line is big, and you have to sort of listen to this. It's almost like rap cadence. Big time negotiators, false healers, and women haters. So it's not, maybe it's not a line you want to use, but it is the only time Dylan did anything using anything around the world word negotiate. I apologize for that. Again, I love the presentation. Thank you so much for doing it.
It's great.
I'm done.
Thank you, Michael. I'm going to ask Arno and Iris if you have any comments, any follow-up questions. I do have a couple of quick questions, but I want to give you a chance to respond to what you
Well,
think.
I would like to give something of an answer to Michael's 2 points. The one that he raised about the decision taker being neutral. That's a label. It cannot cover all cases. I'm not going to contest your experiences with these mental health cases that you had and the judge not being neutral. But the paradigm among the judiciary generally is that they are neutral, and that does not mean that is sufficient. I'll try to give an example from my own experience as a part-time judge in the Court of Appeal in Amsterdam here. We had a case once where it was quite obvious that the attorney of one party was simply not doing a very good job. And that party was going to lose the case. And we discussed this. We have these 3 judges, it's in appeal, so you have three judges sitting. And we discussed this. And my colleague judges were completely in the traditional mode of, that's just bad luck for this party. They, in a way, did not feel able to do anything for this party who just was badly represented. So there you have this citizen who is unfortunate in his choice of an attorney. Now, from a point of view of autonomous law, that's simply the inevitable outcome. It's according to the rules of law in a civil case. From the point of view of responsive law, that's not acceptable, because it will produce an outcome that is according to legal rules, but it will not produce a just outcome. And the only thing that you can do there is some kind of judicial activism, that you try to find a solution that within the rules in which you have to function, you try to find a solution where this omission of this lawyer may be covered or whatever. I'm not going into details because that's very much depending on the jurisdiction that you're in. But that's what I meant on this table with the judge being neutral and passive. And in a responsive law perspective, that's simply not enough. That's what I meant. I didn't mean to pretend that in all cases all judges would be passive. That's
Arno, I did not think you were doing that at all. I was pointing. This is one of the shibboleths. This is one of the myths. This is what law professors are what to teach their students, and it doesn't exist. And I think we have an obligation on our part to let the world know that this lofty aspiration is not met in real life. Does that make sense?
Absolutely.
I apologize. I had not realized that you were a judge, so if I insulted you, please.
No, don't worry.
Okay, good.
I'm not that, I don't identify as a judge at all.
I understand. Thank you.
It's just one of the things that you do in your career. I've been an attorney too, like you.
Yes.
All kinds of stuff. I will be 65 this summer, so.
You're a young man.
A child.
Exactly.
Yeah. I knew that one was coming. Yeah.
Yeah, of course.
Anyway, so and your second point is, well, as for the field of personal injury, that's really, I'm afraid US is a bit of an outlier there.
Okay, that's good to know.
So there is, in what I understand of if the law of damages in the US, there's no longer really a connection between the damage that you suffer and the damages that you can get in a court. Simply, so that's why people would label it a lottery or whatever. And for instance, I think one of the things that really are important is that in Europe we simply have comprehensive insurance coverage for everything. Often it's obligatory, so it's mandatory to have. You can't drive a car if you do not have insurance, and it's an insurance all kinds of legal requirements that will make it a very comprehensive, very. So if you have the bad luck of causing an accident as a driver, you do not suffer any monetary risk. It's simply covered by insurance. It's even covered by insurance when you are not insured. So there's always a professional party there whose role it is to step into this place and to compensate people. And these professional parties, well, it's a matter of culture. All the elements that you mentioned there, you know, like personal injury lawyers with billboards, with bags of money, stuff like that.
Mhm.
I don't think you would see it in other jurisdictions. I'm not saying that you're not seeing the mechanisms. You definitely are seeing the mechanisms, but they're not that powerful. And then in the end, you know, if you want to change things, you shouldn't be too childish about them. Changes go slowly. You just have to continue making that effort for decades, and then you will see change.
Thank you. No, I agree, and I've been trying for 60 years, Arno. You know, I've got a
Good.
decade on you.
And I'm sure you have. I'm sure you have achieved a lot in your life.
I'd like to think I've achieved some, but you know, it's funny as we're talking, I thought about something which I've written about in a couple of law review articles. I supervised a case called Rennie versus Klein that set out in New Jersey, then ultimately the Third Circuit, that psychiatric patients have a qualified right to refuse antipsychotic medication, as it made our client suicidal when he got this drug. And I was at a meeting I was on the state bar committee on whatever, and the cocktail party, you know, the judges drink too much often at these. One of the judges came up to me and he said, Michael, you know what I would, and this is the assignment judge for Essex County, the biggest judge in the biggest county. You know what I would have done if you had brought the Rennie case before me? I said, no, Judge Blake, tell me, knowing it was going to be, I said, I'd have had that son of a bitch taken down behind the courthouse and had him shot. This is the judge talking to me, and I would guess I started teaching in 84, so this would have been 81, 82, 83. And you know, I think I have an answer for everything. I had no answer.
I can
So,
imagine.
I mean, that's just, and again, Arno, you know, when you write this up, I mean, I found all that so interesting. I sort of beg you to add a footnote somewhere saying it may not be this way in every jurisdiction, you know, because I think that would be of great help. And again, I hope
we will add a footnote on one condition.
Yes,
That we can also add the Dylan quote.
of course. Oh, that's my gift to you.
That seems like a fair exchange.
Excellent. Excellent.
Okay, I see David Yamada has a comment or a question.
You're muted, David Yamada.
Hi, everyone. No, I just want to observe, a few years ago, I wrote this long assessment of TJ, and in that analysis, I looked at all the different terms that have generated over the last 30 or 40 years. And, you know, I just came away with the conclusion that everyone's going to have, you know, sort of the term that they think is the most appropriate for their work, their values, and also their jurisdictions, because you know, what's coming out of this conversation is the difference in legal cultures that may make certain terms more appropriate for some nations and maybe less appropriate for others, at the risk of painting with such a broad stroke when it comes to legal cultures, because they can differ from, you know, sometimes town to town, as we know. But so I think that the bigger challenge, and this is going to something that Kim was talking about, is that when we're using our respective terms, it somehow escapes the attention of people who are using different terms for work that is either the same or very similar or complementary. And that's how I think we have to find a better way to, create this sort of marketplace where people can lend, borrow, beg, whatever, in a way where the ideas, the analysis, the studies, and so forth, can be used in the way that's more valuable. Because the one thing that I do find that's commonly shared by this whole, what I'd call sort of giant rubric or community, are very similar values. Maybe with different emphases, but largely within a recognition that it's important that our legal systems and legal cultures change in ways that are I think consistent with almost all of these different modalities. So I think whether it's responsive law or TJ or comprehensive law, integrative law, procedural justice, whatever, I'm kind of in favor of whatever pushes us towards progress. And it's going to be less invested in the term, but whether or not the ideas, the analysis, the information can get through to different legal stakeholders, into classrooms, into courtrooms, into administrative tribunals, and so forth. And I think that's our real challenge here.
Yeah, I want to echo that because David, I'm pretty sure you were there at the conversation in Cincinnati some 20 years ago, maybe more, where there everybody was kind of like the restorative justice people and the collaborative law people and the TJ people. Everybody was saying we need one name. And when I wrote Lawyers as Peacemakers, I actually refused to get into that conversation because I just said there is a movement. There is something happening, and that we don't need to call it the same thing to be part of it. And then some 10 years later, after Peacemakers came out, we called it a summit of 30 people who came together and said they wanted to call it integrative law. So I adopted that. 30 people from all of the different vectors, to use Susan's term. But the only sort of position I have about a name is that it's easier for people to find us if we have one. That responsive law and integrative law haven't met each other yet is a sad thing. But now it's happened. And I think going back to Michael's point about how do you find the people, mostly they have been, my goal has been to be as visible as possible and have them find me. And then have the courage that comes with being in a community to be able to go and do things that they wouldn't do if they were on their own.
Yeah, Kim, if I could just briefly respond, I think obviously, yes, it would be easy if there was one term, but we're 40 years too late for that. You've got decades of respective scholarship using one term or another. Sometimes people use the overlaps, but otherwise, if we were to identify one term and settle on it, people would type that term in and be missing maybe, 3/4 of the stuff out there already.
Yeah. I think that's right. I'm for the one term, I'm thinking more like media. But you're completely right. And as David Wexler was saying, that the RJ people, they didn't like anything having to do with law in the beginning, and they've come around as law has come toward them.
Yeah.
Like the problem solving courts and things like that came toward the restorative justice people, so that they were able to consider that maybe there's something that the law has to offer them, but they really wanted to stay away. And so part of, I call it the movement is what's the easy thing for me to call it. Part of this movement has been that all of these things are coming from different places, but that, we decided that we were going to focus on the values piece, that the different values were giving us this garden of different
And
things.
I
and
think
all-
they have different, there are differences that are important. Like someone mentioned restorative procedural justice. And a lot of people think that is TJ, and that's absolutely wrong. You know what I mean? TJ adds something much more onto that. No problem with procedural justice, but it's not the only thing. I kind of think a list of all the names, you know, this might be considered, you know, might think of this and this and this and this and this and this and this. And you know, with maybe a reference to each or something would do it. But we are all on the same wavelength, but we have somewhat different emphases. And there are definitely things that TJ has that other things don't. There are definitely things other places have that TJ doesn't get involved in. But I think it's you're right. It's a movement. We have no name for it. But if we just say, you know, something comes up where we just sort of mention all of these different things and say they all have some relationship, you know, there's something similar to all of this. And
the
I
same time,
think what Arno did was perfect in that regard.
Yeah, there are, I like to look at it from repressive autonomous, because there are people who are doing, for example, collaborative law from a very autonomous place, not that responsive place. You know, that there are people who are going through the checklist in a restorative justice kind of case that have not made the shift. And so that's part of what we have going on too. We have people who are using the terms in a way that doesn't give it the full experience.
I agree. I just in the chat asked whether there's an article coming up because you know, I think we all agree there's a lot of value in just seeing the levels of interaction and kind of being collaborative about the unique things that different movements can offer and yet the places that there are synergies. And I think the talk today kind of did some of
Sure
that.
did.
Yeah.
Yes.
Maybe the rock song from 68, 69, 70, A Horse with No Name by America would be the better title for this.
Oh, I love
And I
that.
have used
I love
non-Dylan.
it. I love it.
I knew he would write
I
something
have
before he
used
got off
non-Dylan
this.
quotes, so I'm fine with that. I've got a Warren Zevon somewhere. I've got a couple of others. So, you know, but I think, you know, when David said no name, that just jumped out at.
The
I'm
horse
gonna call
with
it
no name.
1969 plus and minus 1 year.
Well, Shelley, to answer your question, we now have a title, so there must be an article.
I think that means you must follow up with the article.
By the way,
Right.
I completely agree with the view expressed by David Yamada. And of course, you know, the label, the title is completely subordinate to the content and the schools of thoughts and the, you know, the values that are under it. That's why I was feeling so hesitant to suggest just another label. And Iris made this wonderful pyramid. It made me feel a bit uncomfortable. And it's also, I think, quite an enterprise, really, quite something to try to describe all these movements and, you know, to do justice to them. It's all a bit sensitive. But what I really think that what is essential, and that was also touched upon by David, is, you know, it's the only downside of all this plurality, of all these beautiful flowers in your garden, Kim, is that people are not able to find all the scholarship that is there, because it's behind different search words, really. So if we could address that, maybe we can try to do something like that. But I feel uncomfortable because it's so pretentious. Oh yes, we have the overall view here, because we don't, of course. And
another term to look for is relational law.
yeah.
Yeah, for
Susan
sure.
Brooks.
Yeah.
So what about if Iris and I make a draft and you guys comment on it? Because, you know, no one has the overview. We don't.
I
I'm
think
happy
that's a
to.
fantastic idea. Yeah, be very
The
happy.
song was 1971, by the way, Arno. I just checked.
The horse. So
I was
the
off by
title
a
would be-
year. Shit.
The
you know.
title will be The Horse with No Name.
Yeah. colon, blah, blah, blah. Yeah.
Yeah,
And in it, in it, we will provide a lot of names.
exactly.
We
Yes,
try to be as
I think it
comprehensive
makes-
as
I think it
possible.
makes a great point, yeah.
I think it does too. Okay, so now we're looking forward to that draft in our inbox, but we won't expect it this afternoon as we would if it was Michael Perlin who was under.
Right.
I'm afraid not.
It's already there, if it's Michael,
Money you decide.
while we were here on the call.
You guys are killing me.
Okay, everybody, I think that we are nearing the end of our time, which has flown, which has to mean that it was a super engaging talk. So thank you so
Wonderful.
much.
Thank you.
And as soon as I get the recording processed, I'll put it up onto YouTube, and then others can have the pleasure of hearing it as well. So thank you.
Thank you again.
Thank you, everyone.
Capture the
Thanks
chat
so
before we
much.
close.
It was one. Yeah, so we will,
Yeah.
Kim. Don't worry. We know.
Yes.
It was
Yeah.
wonderful to see you all.
Bye now. Be well, everyone.
Take care,
Wonderful,
everybody.
wonderful. Thank you so much.
And Shelley, thank you again for putting this